legislation which he and I are introducing today, which we call the National Labor Relations Board Reform Act. Our legislation is very simple. It will change the NLRB from an advocate to an umpire. That's the role the National Labor Relations Board was always supposed to have. It was created 79 years ago to act as an impartial umpire in labor disputes that threaten the free flow of commerce. The board's decisions affect millions of private sector workers, but over time, the board has become an advocate for one interest group or the other, changing positions with each new administration. There are three significant problems that the board faces today. Number one, the biggest problem is partisan advocacy. Today, the majority of the five-member board is made up of appointees who follow President Obama's political leanings. He's appointed 3 labor union lawyers to the board. Number two, the board also has a freewheeling advocate for its general counsel. The board's most recent general counsels have been exceeding their statutory authority and bringing questionable cases that threaten American jobs and threaten sending overseas manufacturing jobs that we need to keep here. Number three, the National Labor Relations Board has been slow to resolve disputes. Last year, 109 cases, that's 30% of the board's caseload, were pending for more than a year. Occasionally, someone will say to me, well, if Republicans were to win the Senate, what would Republicans do? Well, what we would do is try to come up with sensible proposals that lead us in the right direction, proposals that have so much common sense that they attract the support of enough Democrats and the House of Representatives and the President to become law. This is one such proposal. Our bill provides 3 solutions to the problems identified. Number one, it would end partisan advocacy on the National Labor Relations Board. The board would become a 6-member board of 3 Republicans and 3 Democrats. A majority of 4 will require both sides to find a middle ground. Number two, it reins in the general counsel. Businesses and unions would be able to challenge complaints filed by general counsel by taking them to the federal district court, and they will have greater transparency about the basis and legal reasoning for the charges brought by the general counsel. Number three, our legislation would encourage timely decisions. First, either party in a case before the board may appeal to a federal court of appeals if the board fails to reach a decision in 1 year. And second, funding for the entire NLRB would be reduced by 20% if the board's not able to decide 90% of its cases within 1 year over the first 2-year period following reform. Our bill would offer these solutions without taking away one single right, one single remedy from any employee, business, or union. And Mr. President, with each new administration, the pendulum at the NLRB has swung further from the middle, further away from being an umpire. The result is that labor policy whipsaws back and forth, taking employees and employers for a wild ride. This has happened under most administrations, but has been worse under the current administration. The minority leader mentioned several of those examples. Under the partisan advocacy of today's National Labor Relations Board, workers are losing their right to privacy. The board's embarking on a regulatory effort to expand requirements that employers give names and addresses to union organizers so that more personal information about these employees may be given to the organizing union. These include your telephone number, your email address, the employee's work location, the employee's shift, the job classification. They propose doing everything but attaching a GPS to the lapel of each employee. In my state of Tennessee, for example, we've had an ongoing organizing effort in the Volkswagen plant in Chattanooga. In a secret election ballot last February, employees at the Volkswagen plant said, we don't want a union, we don't need a union. 712 to 626, they rejected the United Auto Workers' bid to unionize the plant. Now imagine if you're one of those 712 employees who voted against unionizing. Now organizers can get your private email address and all this other personal information. Or here's another example. Small factions of employees within single stores now have a path to forming their own unions. In 2011, the board suddenly adopted a new way to define what makes a local union bargaining unit. The board changed the law so that any group of employees with an overwhelming community of interest could become a bargaining unit and therefore a union. At the same time, the board's moving a regulation to limit the employer's ability to question which employees should be in a bargaining union. This allows a union to cherry-pick employees who will be most likely to support forming a union. How's this worked in the real world? Well, here's an example. The board just approved a bargaining unit for cosmetic and fragrance employees in Macy's department store. Not the shoe salespeople, not the ladies' fashion employees, not the juniors department, just cosmetic and fragrance. Now imagine if every department of the Macy's decided to form a union. The employer would have dozens of different groups to negotiate with, and the different unions would be fighting each other over who got the better raises, break rooms in terms of employment. During this administration, the NLRB has ruled that common employment practices, common employment policies are unfair labor practices, such as, and Senator Scott brought this up in a hearing the other day, the NLRB has said that an employer may not have a policy that requires employees to be courteous to customers and fellow employees. An employer may not have a policy to require an employee to be courteous to customers and fellow employees, or prohibiting employees from making negative comments about the business that employs them on social media, or selecting arbitration for employment disputes. Our solution? Senator McConnell and I would solve this by requiring a 6-member board of 3 Republicans and 3 Democrats. Like the Federal Election Commission, a majority of 4 will require both sides to find a middle ground. Now here's the second problem. The board's general counsel is acting like a freewheeling advocate, stretching labor law to its limits, sometimes beyond its limits. For example, in 2011, the general counsel moved to stop Boeing from building new airplanes at a non-union plant in South Carolina. The general counsel to the NLRB jeopardized a $1 billion factory and hundreds of jobs with this move. But even worse, he tried to make the case that a unionized American company can't expand its operations into one of the 24 states, like Tennessee, with right-to-work laws, which protect a worker's right to join or not to join a union. The general counsel eventually withdrew this outrageous complaint against Boeing, but if it had set a precedent, jobs would have fled overseas as manufacturers looked to find a competitive environment in which to make and sell cars around the world. We want to make sure that manufacturers like Boeing, like Nissan, like General Motors can have a competitive environment in the United States in which they can make airplanes and cars and other goods and sell them around the world. We don't want them making them in Mexico and Japan and Europe or somewhere else because we undermine right-to-work laws. Our solution would allow employers and unions to challenge complaints filed against them by the general counsel, to challenge them in federal court, and give employers and unions new rights to learn the basis and legal reasoning of charges filed against them. Finally, the NLRB is taking too long to resolve cases. For example, one case has been pending at the board for more than 7 years. The case involves the question of whether an employer has to allow labor union organizers access to private property. Our solution? Senator McConnell and I encourage a timely resolution of cases first by allowing either party to appeal to a federal court of appeals for a de novo or fresh review if the board fails to reach a decision on the case within 1 year. And to further incentivize timely resolution, we include the threat of a 20% budget cut to the board if 90% of its cases are not decided within a year. So, Mr. President, in conclusion, while the increasing partisanship at the board has occurred in Republican administrations as well as Democratic administrations, it has reached a climax in this administration. 3 of this president's recent nominees came to the board from a major labor union's leadership. One labor law professor at a major university recently said she can't even use the most recent labor law textbook. Instead, she has to resort to handing out NLRB decisions. The decisions changing the law are coming out so rapidly that the NLRB is venturing into new territory with its efforts at rulemaking. This is no way to maintain a national labor law policy. Our plan, the NLRB Reform Act, will first end partisan advocacy, second, rein in the General Counsel, and third, encourage timely decisions. And our bill would offer these solutions without taking away one right or one remedy from one employee, one business, or one union. I hope that my colleagues will carefully review this proposal in considering co-sponsoring the NLRB Reform Act. I thank the President.